So I'm really happy to see all of the students that persevered and the teachers that supported that. I'm excited. So this will be historic, and it will be something you'll recall at your wedding or something. Civil commitment, who knows? I am a lobbyist in Nevada. I have a small lobbying firm, but I'm also the executive director of the Nevada Center for Civic Engagement, and that is the home for We the People programs in Nevada. So I'm super excited to be here today. And my colleagues will introduce themselves.
So good afternoon, and likewise, I am so pleased that you guys are willing to be a part of this, even though we have all met so many different challenges. We have had our own technical difficulties. I've been flung out into the outer darkness about 3 times today, and so I totally understand where you guys are coming from, but I'm so glad that you guys are willing to persevere. My name is Lynn Uzzell. I teach American politics at the University of Virginia.
My name is Lindsey Draper. I really do have to acknowledge the fact that the people who've talked before me have done a wonderful job of stretching this out so Cole could come online. So I'm thrilled to see that he's here, as are his teammates. So anyway, I retired from the juvenile court bench in Milwaukee County, Wisconsin, and I currently am a member of the National Task Force on Lawyer Wellbeing.
So that's a little bit about us. How about you tell us about you, what you were doing, and I interrupted, sorry.
Hi, I'm Debord, and I'm a junior at Findlay High School.
Hi, my name is Hannah Mueller, and I am also a junior.
My name is Cole Sprague, and I'm
Jessica, you're muted.
Yeah, make sure to mute yourself when you're not speaking, Cole, because I'm getting a little bit of distortion. Sorry.
Yeah.
Okay, and you have a teacher as well and others. So we understand the challenges of this experiment, the great experiment. You know, it's kind of like, will democracy work? I don't know. We'll see. Let's see. So will Zoom work? I don't know. Let's see. So moving on, we'll go ahead and start the hearing. Question 1, the state sent delegates to the Philadelphia Convention to join with other states, quote, in devising and discussing all such alterations and further provisions as may be necessary to render the federal constitution adequate to the exigencies of the Union. To what extent, if any, did the delegates follow their instructions? What experience of state governments under their new constitutions after independence might have influenced the creation of the Constitution? Do the decisions of the United States Supreme Court function as a continuing constitutional convention? Continuing constitutional convention. Why or why not? Please begin.
Mr. Chairman, the 55 delegates to the Philadelphia Convention followed their instructions to the extent that the framers' actions were necessary to render the federal Constitution adequate to address the urgent needs of the nation. From 1781 to 1787, the members of the Confederation Congress made 8 attempts at amending the Articles of Confederation. However, the inability of both the national government to effectively govern and the states failing to work together left the Philadelphia Convention with limited options to save the fledgling nation. As James Madison noted in The Vices of the American Political System in 1787, the inadequacy of Congress to raise revenue under the Articles by collecting import taxes and regulating commerce created a severe financial burden on the country, which limited the nation's ability to protect the states and adjust their needs as a whole. This led to events such as Shays' Rebellion, the Oconee and Coldwater Indian Wars, which were all ended by local militias unhelped by the central government. While most framers had not originally intended to create a new constitution, they quickly realized that in order to have the ability to tax, regulate commerce, and defend the states, a new constitution was essential for America to survive.
Mr. Chairman, the major experiences the early state constitutions had on the Constitution was, in the words of historian Jack Turner Maine, that they became the laboratories for testing theories, trying the institutions in various forms that presently appear in the Constitution of the United States and other countries. First, it's important to realize that the testing of the theories under the state constitutions did not occur in a vacuum. Instead, the states drew upon their experiences to tinker with their governments, as seen with the preoccupation with separation of powers in response to the grievances against the crown before the Revolution. Later, the development of practical mechanisms such as checks and balances were applied in response to legislatively dominated government from 1776 to 1787. The Massachusetts Constitution of 1780 included both, as well as a bicameral legislature, and has been considered by many to have provided a blueprint for the Constitution. The state constitutions also provided value in terms of what not to do, as seen with the Pennsylvania Constitution. While considered the most democratic of all the early state constitutions, it became a mobocracy subject to the popular passions of the electorate in order to be re-elected to a one-year term in the unicameral legislature.
Mr. Chairman, the decisions of the Supreme Court have acted as a continuation of the Constitutional Convention to the extent that the use of judicial review has enabled the court to interpret and apply the Constitution to circumstances and conditions that did not exist in 1787. While the framers could not have foreseen the technological and cultural changes that would occur over the next 231 years, the principle of judicial review has enabled the Supreme Court to act as an ongoing constitutional convention. As Alexander Hamilton explained in Federalist No. 78, and Chief Justice John Marshall decided in the 1803 case of Marbury versus Madison, judicial review enables the Supreme Court to determine if the acts and actions of the legislative and executive branches are consistent with the Constitution. Through judicial review, the Supreme Court has been able to apply the Constitution to many different circumstances, such as the 1965 Griswold versus Connecticut case, which established the right to marital privacy by applying portions of the 3rd, 4th, 5th, 9th, and 14th Amendments. This created a basis for the court's opinion on the 1973 Roe versus Wade case and the 2015 Obergefell versus Hodges case. While the court doesn't amend the Constitution, its decisions impact how it is interpreted, which in effect enables it to act as a continuous constitutional convention.
All right, so we'll stop there and jump into follow-up questions. Thank you for that. Explain for me the principle of timeliness in establishing the rule of law and what government institutions are supposed to do. There's deliberate delay through different structures that want to reduce the speed in which government acts, and then there's those that want to be more deliberative. Explain to me how that was balanced at the Constitutional Convention, the response to the urgency, but also the preservation of necessary deliberation to ensure everyone agreed.
The Constitutional Convention took place between the months of March and September, so it certainly wasn't, Rome certainly wasn't built in a day, but it had some time. If the Articles of Confederation weren't amended and addressed before the time that they were, then events like such as the War of 1812 would have happened, and the outcome would not have been as America had today.
Okay, let me ask. Go ahead.
To go further with that kind of, the War of 1812, America would not have been able to defend itself because Congress didn't have the ability to make money. They didn't have the ability to tax, so it would have been futile.
Let me ask you, following up on your contention that through judicial review, the Supreme Court acts like a continuing constitutional convention. But couldn't the reverse be argued, that when the court exercises judicial review, it is rather to bring the other branches back to the original Constitution? I mean, wasn't that the case when in Marbury versus Madison, Justice Marshall said, by Congress passing this law, they are going beyond. They're changing the Constitution. I'm bringing them back to what the Constitution actually means. Isn't that fixing the Constitution in place rather than acting as a constitutional convention? Cole, you're muted.
In my opinion, no, because when the court makes a decision and when it interprets the law, it usually a lot of times actually deviates from what people think the Constitution means, or what it traditionally means. So through the court's interpretation, it effectively changes the Constitution. Like, for example, in the Roe versus Wade case, like the Constitution doesn't really have anything about it, about abortion, right? But then the court said, well, the right to medical privacy means that a person can have the right to abort their pregnancy. And so someone could argue that that effectively changed the Constitution because traditionally no one interpreted it that way, but they implied it and therefore it changed the law.
Okay, so let me just ask a quick follow-up question. So some of the judicial review cases has the effect of changing the Constitution, and others do not then have the effect of changing the Constitution. So is there a problem then with the Supreme Court changing the Constitution by the fiat of 9 unelected judges?
I think that one depends a lot on your perspective. In my opinion, I think sometimes instead of upholding the law, justices will insert their own opinion into their decision. I don't think that's something that should be done. But then again, that all depends on your perspective, because like people can make arguments for any side, any angle.
I actually disagree with Cole just a little bit, and this is going back to your first part of the question. I do think they try their hardest to always bring it back. Yes, they may interpret what was originally put in the Constitution, but they always try their hardest to stick to the Constitution. Yes, we may have not had a complete right to privacy, but it was hinted at within the First, Third, Fourth, Fifth, Ninth, and 14th Amendments. Yes, it didn't straight up say we have a right to privacy. It was instilled in there that we did have a right. The Supreme Court only pushes that idea forward. Yes, it may have not said it completely, but they confirm that that idea was in the Constitution itself.
Really
One of the
quickly. Go.
one of the modern jobs of the Supreme Court is to adapt the Constitution to modern technologies. I don't think the founding fathers would have thought of abortion as something that would be so like widespread when the Constitution was written in 1787. But the Supreme Court has adapted that over time.
Really quickly, your statement. Okay.
Well, we've had a little bit of a delay with this one, Mr. Draper. If you want to ask your question, let's add 30 or 40 seconds to.
Yeah, I think that's a good idea.
Yeah.
Okay, very quickly, your statement implied that all 55 of the people who showed up in Philadelphia basically were of the same mind. Let's get this right. Let's rewrite this thing. Is that accurate?
No, not at first. They weren't all in the mindset of rewriting the Constitution. They wanted to, at first, not the Constitution, the Articles. They were trying at first to amend it and change it without having to completely rewrite the Articles, but they found out after through trial and error of trying to amend the Articles that they were having issues and they needed to rewrite it to where it would be a little bit easier compared to what it was under the Articles.
Okay, thank you. All right.
Thank you all. All right, just gonna be super brief here. Thank you so much for your engagement. I think you addressed the key details. I think of the question. I think what would want a little bit more of is sometimes analysis is great, but it's strengthened when there's some evidence or some you know, your thoughts are fascinating, my thoughts are fascinating, but if my thoughts are also said by other people, then that even makes them more fascinating. So I think that's one thing that I was wanting from your presentation was a little bit more incorporation and analysis of some other work and stuff. But other than that, I appreciated your engagement, and I think we could have had a very interesting conversation. Thank you.
Yes, and likewise, I thought that you guys did a really good job of engaging with the question and engaging with us. And especially, I think you guys showed some great grace under fire, because we were all really nervous about all the various technological problems. And we've been dealing with this all day and all day yesterday. And I thought you guys really played it cool, all things considered. Like my colleague, Mr. Delap, I also thought that your testimony would have benefited from more examples and more diversified examples. So, I mean, I get that Roe v. Wade was, you know, a great example, but to keep hammering on the same example is not as good as maybe bringing in different aspects and different court cases or examples would have been better.
So I don't have a whole lot that differs a great deal. I really appreciated the fact that one of the things you did for me was say, you know, Massachusetts contributed a lot. Pennsylvania gave a real good example of what not to do. There were some pieces of this that I found refreshing. I also found it fascinating watching as Cole got his exercises and went through assorted things happening there. Anyway, it was fun listening to you all. Thank you.